All right, settle down, students. Settle down and pay close attention. Today's explainer is definitely not a casual overview. This is a masterclass designed specifically for you to secure a full 16 marks on the Indian Contract Act 1872. We're dissecting a massive cornerstone exam question today: the rights, liabilities, and the exact extent of liability of a co-surety. If you follow the structure I'm about to give you perfectly, the KSLU examiner will literally have no choice but to award you top marks. Okay, let's dive right into this exact exam blueprint. Take out your notebooks and open up your bare acts.
Here is your synopsis: intro, rights, liabilities, Kaluram case, extent of liability, Damodar case. I want you to draw this exact synopsis on page 1 of your answer booklets. It grabs the evaluator's attention immediately and proves you know both your statutory provisions and your landmark judgments. Right, let's get into it. Roman numeral 1, Introduction to Co-Sureties. Strictly underline this Roman numeral on your scripts before you write a single word of the definition. In law, structure is everything. An unstructured answer is a failed answer. Co-sureties: two or more persons who jointly or severally guarantee the same debt or duty of a principal debtor. Now read that terminology carefully. Under a contract of guarantee in our Act, when more than one person steps up to guarantee the exact same debt, they legally become co-sureties. Whether they do this jointly together or severally completely apart, the core unifying factor under Sections 146, 147, and 128 is that the underlying debt or the duty of the principal debtor remains identical.
Binding conditions: same or separate contracts, equal or different limits of liability. So let me break this down for you. How do co-sureties actually bind themselves? Well, they might all sign the exact same single guarantee document, or, and this happens often, they might sign entirely separate contracts on different dates without even knowing the other sureties exist. Plus, they might agree to equal limits of liability or completely different financial caps. But legally, what matters is that they are tethered to the same core debt.
That brings us to our next major subheading. Write down Roman numeral 2, Rights of Co-Sureties. Because once a person takes on this massive, terrifying responsibility, the law simply has to afford them certain protections against their fellow guarantors.
And the first right is purely statutory: right to contribution. Section 146, co-sureties are liable to contribute equally towards the debt unless there is a contract to the contrary. This bare act provision is incredibly strict. In practice, what this means is if the principal debtor defaults and the creditor decides to squeeze just one surety for the entire amount, that paying surety isn't just left to suffer alone. No. If one surety pays more than his share, he possesses an absolute, legally enforceable right to recover that excess from the other co-sureties equally.
Here is the required illustration you will use. A, B, C guarantee 9,000 rupees. Each is liable for 3,000 rupees. If A pays 9,000 rupees, he recovers 3,000 rupees each from B and C. Let's mechanically break down this math. The total debt is 9,000. Because there's no contract saying otherwise, the default position of the law is equal contribution. 9,000 divided by 3 sureties is 3,000 each. If the creditor forces A to pay the full 9,000, A exercises his statutory right to contribution, dragging B and C in for 3,000 each. Listen to me carefully. If you miss writing this illustration in your exam, you lose 2 marks instantly. Illustrations prove to the evaluator that you actually understand the mechanics of the law.
But hold on. What if their financial commitments aren't equal? Look at the right-in case of different liabilities, Section 147. Contribution is made proportionately when maximum liabilities differ. Let's dissect the logic of Section 147 with a very specific scenario. Imagine A guarantees for a maximum of 10,000 rupees, B for 20,000, and C for 40,000. But the total debt that actually defaults is 30,000 rupees. They don't just split that equally here. Because they undertook different maximum liabilities, that 30,000 rupee debt is shared proportionately based on their individual limits. You must explicitly state this proportionate sharing rule for Section 147 to get full credit.
Please copy these remaining rights down precisely. Number 3, right to share benefits of securities. And number 4, right to indemnity. For right number 3, understand that co-sureties are strictly entitled to the benefit of any securities held by the creditor. If a bank holds property as collateral and one surety pays off the loan, that paying surety steps directly into the shoes of the bank and gets the benefit of those securities. And for right number 4, remember that every co-surety has an absolute right to be indemnified by the principal debtor. The debtor caused this mess, therefore the debtor must legally reimburse the sureties for every single rupee paid.
We now shift our focus entirely. Write down Roman numeral 3, Liabilities of Co-Sureties. While the law grants you rights, it also imposes severe, inescapable obligations. A contract of guarantee is a heavy burden, students, and you must articulate these liabilities with complete clarity.
Note these 3 pillars of liability perfectly. 1. Equal liability under Section 146. 2. Joint and several liability. 3. Liability even if others not sued. Let me pause and explain this. First, in the absence of an agreement, liability is strictly equal. It is absolutely not based on a surety's personal financial capacity to pay. Second, liability is joint and several. The creditor is the absolute master of the situation here. They can recover the entire debt from any one single surety or all of them together. Third, a surety cannot stand up in court and cry, "Why are you only suing me? Go sue the other co-sureties first." The law explicitly dictates you cannot escape liability simply because your co-sureties aren't being sued alongside you.
Now, what's really going to set your answer apart is judicial precedent. You simply cannot write a KSLU answer without case laws. Pen down this heading immediately.
Sureties are liable unless discharged, and rights like benefit of securities must be protected. Students, I want you to write this case law in a separate boxed format on your paper. Let's break this down. The brief background facts of the case are that the creditor possessed certain securities belonging to the principal debtor, but completely failed to protect them. The final ratio decidendi, the binding verdict of the court, was incredibly clear. While sureties are strictly liable unless properly discharged, the creditor cannot act negligently with collateral. The absolute relevance of this case to our topic is that a surety's right to the benefit of securities is a strictly protected legal shield. If the creditor loses those securities, the surety is discharged to that exact extent. Highlight this verdict. It's a game changer for your marks.
Next, we write Roman numeral 4, extent of surety liability. This section dictates the absolute boundaries of Section 128 of the Indian Contract Act. Just how far does the liability of a guarantor stretch?
Read this carefully. Co-extensive liability, Section 128. Liability is co-extensive with the principal debtor, unless otherwise provided by contract. So, what on earth does co-extensive actually mean in a legal exam? You need to meticulously explain this. It means the surety is liable for the entire debt exactly, precisely like the debtor. If the principal debtor owes the principal loan amount plus accumulated interest plus the ridiculous legal expenses of the recovery suit, guess what? The surety owes the principal amount, the interest, and the legal expenses. The breadth of the liability is a perfect mirror image of the debtor's liability, unless they cleverly limited it in their original contract.
And now we've arrived at our second landmark judgment. This is a crucial Supreme Court precedent regarding the timing and immediacy of liability. Write down the heading, Bank of Bihar v. Damodar.
Let us read the Supreme Court's holding verbatim. Bank of Bihar v. Damodar Prasad. The Supreme Court held that a creditor can proceed directly against the surety and liability is immediate. Let me explain exactly why this is so critical. The background facts here involve a bank trying to recover a loan and the surety arrogantly arguing, go sell the principal debtor's property first, exhaust all your remedies against him, and only then come to me. The Supreme Court decisively shut this nonsense down. The ratio decidendi is that the surety's liability arises immediately the very second the principal debtor defaults. The absolute relevance here? The creditor absolutely does not need to sue the debtor first. Now, here is your exam tip. Underline this case name, Bank of Bihar v. Damodar Prasad, to immediately capture the evaluator's attention for a 16-mark answer. It proves to them you know the harsh procedural realities of recovery.
Now, are there caveats to this brutal liability? Yes. Limited by contract regarding amount or transactions, and continues until discharged by law, contract, or conduct. A smart surety will always limit their exposure. They do this by capping their liability to a specific maximum amount or strictly limiting it to a single transaction. But mark my words, unless they are officially discharged, whether by operation of law, a specific discharge contract, or by the conduct of the parties fundamentally altering the terms, they remain firmly on the hook.
Finally, we reach the conclusion. Balancing creditor protection and co-surety fairness. In your closing paragraph, you must deliver a strong summary. State clearly that the Indian Contract Act carefully balances two opposing forces. On one side, it provides strong, immediate, coextensive protection to the creditor, allowing them to recover from any surety without a moment's delay. On the exact opposite side, it maintains strict fairness among the co-sureties themselves through the powerful rights of equal or proportionate contribution, and that absolute right to indemnity from the defaulting debtor. I am going to leave you, my law students, with this final, provocative thought. If a surety's liability is immediate and perfectly coextensive, who really bears the true burden of the guarantee? Contemplate the heavy, unforgiving reality of signing a contract of guarantee. You're not just a polite backup. In the eyes of the creditor and the law, the moment a default occurs, you are the primary target. Study these provisions, practice these structures, write down your case laws in those boxes exactly like I told you, and I guarantee you will command top marks. Class dismissed.